SJC-12327, the trustees of the Cambridge Point Condominium and individuals v. Cambridge Point LLC and others.
Still morning, Mr. Alcock. Good morning.
Good morning, Your Honor. May it please the Court. My name is Edmund Alcock, and I represent the Cambridge Point Condominium Trust. We respectfully submit that the bylaw provision contained within the condominium trust documents in this case is invalid and unenforceable for two primary reasons. The first reason is that it constitutes an improper transfer of power from the board to the unit owners, which conflicts with the Act and I think violates the Act. And alternatively or additionally, the provision itself, we believe, is unenforceable for public policy reasons in that it interferes with the condominium association's relationship with its council, and it is intended to, and effectively in this case, actually has prevented access to the court system to redress a wrong, which we believe was occasioned by the developer in this case. I think where I would start is this court, in many condominium cases, Strauss, Scully, Barclay, have always referred to our Act, 183A, as an enabling act. And by using that term, the courts have repeatedly said that matters not specifically addressed to the statute, or not specifically addressed in the statute, are to be worked out by the involved parties.
Can I ask you something? When you laid out your grounds, you first said about how it conflicts with the Act, then you talked about public policy, and you said it interferes with the relationship with council and also access to the courts. What you didn't say, and I don't know if this is conspicuous, is that it violates public policy because it's overreaching, according to Barclay.
Well, yes, Your Honor. It's not conspicuous. I think the standard under Barclay for what is a violation of public policy is either it's the product of fraud or it's overreaching. Right. So I think the overreaching is why it actually violates the public policy.
Okay, so you're not excluding that?
Oh, absolutely not, Your Honor. So with respect to the matters that are addressed in the statute, the litigation power, which is conferred expressly on the board in condominium associations under the Act, actually is a matter that is specifically addressed in the statute and is a matter that should not be left to the parties to work out. It's not something that should be modified. And in fact, this court, in numerous cases, Siegel versus Leader, Barish versus Bornstein, has specifically indicated that the power to sue and to be sued on matters involving the common elements lies exclusively with the condominium board. In fact, in Barish versus Bornstein, this court even expanded that power to the point where it allowed the board to bring claims that are really unit owner claims for breach of implied warranty of habitability, but where the court recognized the hybrid nature of condominiums and said, okay, well, if we have a common area defect that is causing that implied warranty of habitability to be breached, we will allow the board as the exclusive litigation representative to bring those claims.
Does that apply to any percentage of unit owners? Because here we have a supermajority of 80%, right?
Correct.
What if it was a 51% bylaw?
Your Honor, I think that any percentage actually conflicts with the Act. I think the court, when the legislature, when they put this Act together, recognized the hybrid nature of condominium associations, recognized that we're giving the power to administer the common elements to the board, which is elected by the unit owners. And in fact, the legislature actually went out of its way to find various carve-outs where they would check board power. I think I counted 6 different ones involving improvements, termination of the condo, which actually I find kind of funny, is 75% to terminate the condo, but 80% here to file a lawsuit. Development rights, things of that nature. I think any check on the board litigation power whether it's 51%, 40%, 67%, should come from the legislature, not from the developer. For instance, I believe Florida has a litigation check, and it's legislative, and it's for matters involving collectively more than $100,000, and there they said it's a vote of majority present at a meeting at which a quorum is present. So the quorum requirement in Florida, I think, is 20%. So you could have as little as 11% in that case if you had a majority of the 20. I also think that in this case, we look to our act, we look to Section 12D, which talks about bylaw provisions which may be included or shall be included pursuant to the statute. The legislature said, oh, you know, one thing that we think about with respect to litigation is the condominium association could adopt an arbitration bylaw so that all disputes go to arbitration. So the legislature looked at perhaps the forum, but didn't decide, but specifically decided not to check or balance the power as they did with respect to these other 6 provisions.
Don't we start with Barclay?
Well, I think we start with Barclay once we get into public policy.
Well, no, I think it may back up, because I think we start with Barclay, or perhaps we start with Barclay, because it says the governance is up to the parties, and we're not going to step in unless there's a violation, et cetera.
Well, yes, but Your Honor, Barclay, Scully, and Strauss, they all talk about that enabling nature. But if you read the language very carefully, it says they have the ability to work out matters that are not specifically addressed by the statute. So I say this litigation power is specifically addressed by the statute, so that's where we really start.
And which provision specifically addresses this? The provision that says that the condominium trustees have the sole right to sue or be sued?
Correct, Your Honor. That's 183A, Section 10B4.
But they do have the sole right here to do that. It's just it's restricted by this vote, right?
Well, Your Honor, I say that actually transfers it. I mean, if the legislature said, we recognize that you as unit owners get to elect this board, and this board gets to do certain things. You get to repair the common elements, you get to, you know, figure out what the budget is, and you get to sue. And in this case, sue.
But in Barclay, the developer got to pick 2 out of the 3 people, right? So they essentially had control, and we said that was okay, right?
Correct, Your Honor. And there was a period of developer control here. And the distinction in Barclay is the issue of control, the issue of developer trustee control for a period of time is not a matter that is specifically addressed in our act. It is addressed in the Uniform Act, it is addressed in Ukiah, but it is not addressed in our act. So I think what ultimately Judge Liakos decided in Barclay was correct. He looked at the Uniform Act and said, yeah, it's normal for a developer to have a period of protective control while he's marketing and selling units. The developer had that period here. The developer had that period for a number of years. The issue here is whether or not that litigation power has been reversed. It's been actually...
But isn't the problem here is that, I mean, Justice Gaziano said the percentage, doesn't that matter? I mean, it seems like some percentage would be appropriate, but a percentage that would allow essentially a small group of unit owners to control this seems different than a 50% rule, but you don't find it that way.
I don't, and I guess one reason I would suggest I don't is because I would point your honors to the Uniform Condominium Act, which, speaking of Barclay, I know Judge Liakos looked extensively at the Uniform Condominium Act in Barclay to figure out the developer control provision, and the Uniform Condominium Act suggests, specifically states that there cannot be a provision in the condominium documents that gives a more favorable outcome to the developer. And the more modern iteration of the Uniform Condominium Act, something which is called the Uniform Common Ownership Interest Act, commonly referred to as UKIOA, actually has a provision in it that says there cannot be any limitation, any voting requirement on a board's right to commence litigation.
Which our legislature chose not to adopt, obviously.
Yes, no, our
Well,
legislature...
certainly the Uniform Act.
No, Your Honor, our legislature hasn't adopted UCA or UKIOA, but in some of these cases, Scully, Barish, Strauss, Barkley, our courts have looked to UCA and UKIOA for guidance where we don't have a specific case or issue on point. And to Justice Kafka's question and your question is, well, what about some other percentage? Like, I don't know how you would do that. I think that's a legislative role, and I think what I'm suggesting is the modern interpretations of condominium governance, much more modern than our act, which I think was 1963, suggest that that type of restriction is inappropriate.
Well, let me ask you on the issue of, and I don't think we're dealing with fraud, but on the issue of overreaching. How do you address counsel's argument that these are recorded instruments, unit owners can look at these and they can either buy or not buy, and they basically caveat emptor, they bought, and this is what they have?
Yeah, I think the best answer to that is to cite this court's decisions in Strauss, which is a 1994 decision, and then this court's decision in Scully that issued some 17 years later, which distinguished itself from Strauss. In Strauss, there was an illegal master deed provision that provided that unit owners could expand their units. And that provision conflicted with Section 5A, which says when you expand your units, it changes the percentage interest, you need 100% consent. And what the court in Strauss said, because the same argument was made, the argument was made, well, everybody bought in knowing that we could expand units, that's what's in the master deed. And in Strauss, the court said, the fact that unit owners acquired their interest with notice of the existence of an unlawful master deed provision does not bind them to accept it. To bind the owners in such circumstances would mean that any provision in a master deed would overrule the requirements of the condominium statute, and the legislature could not have intended such a result. Now, fast forward to Scully, some 17 years later, and there was a violation of Section 5A, and the violation there occurred as a result of a lawsuit between the developer and the Phase 1 unit owners. And they settled their lawsuit to basically waive the provisions of Section 5A and utilize a percentage that was different than the statute. And what this court said is that Scully, this situation is different from Strauss. It's a waiver agreement. They said in Strauss, there was no waiver by agreement of the parties. There was no indication in Scully, in Strauss, that the terms of the master deed were drafted by anyone other than the developer. So the argument that somehow this is something that just because you buy into doesn't mean that it can't be unlawful, and this court has held that clearly in Strauss. And I think it also undermines the reality of a condominium master deed.
Can I ask, in Strauss and Scully, we affirm we don't reverse, which you're asking us to reverse, right? So these are all deferential review cases, it seems like.
Well, in Strauss, the court said the expansions were invalid, but they didn't tear the house down. Mm-hmm. In Scully, they said this isn't a Strauss because the parties negotiated, settled it, and they enforce the public policy.
Even though it was sort of expressly in violation of the statute.
It was expressly violation, but the parties negotiated it, and I think the court said there was an overriding public policy concern in actually enforcing a settlement agreement. Here, the contrary public policy concern is we have a condominium association that has significant water damage defects and is being prevented from having that case heard on the merits. Now, in terms of actual provisions, I know I cited some trial court decisions. I believe one that was actually authored by Justice Gantz when he was back on the business litigation session back in 2000, where we're talking about developer, trustee.
He talks, he can speak better than I can about what he wrote, but he talked about a fiduciary duty.
Well, but it was an exculpatory provision
And do you
in
think-
favor of a developer trustee.
And are you suggesting we should adopt that fiduciary duty analysis here?
I do, but to me, if a developer trustee can't exculpate himself from liability by writing so in the condominium documents, the natural progression of the law is that the developer similarly can't effectively prevent the condominium trust from suing him at all.
If I can ask you a somewhat separate question. What remedy, if any, is there for a unit owner where the board enters into litigation which turns out to cost millions of dollars?
The great thing about condominiums, Your Honor, is they are the purest form of democracy. And when we were talking about 51%, and I've had it happen to me, when there's an ongoing litigation which the masses don't like, what they do is they remove the board, and they put a new board in, and then they have the ability and the control to do whatever they want, to dismiss the litigation, to settle the litigation.
They have any means of bringing an action against anybody to recoup the substantial expense they have incurred?
A unit owner would have the ability, if a board acted in violation of its fiduciary responsibility to the entire association, would have the ability to bring a derivative action against those individual board members for breach of their fiduciary duty. So the answer is, there is a remedy other than the electoral process.
Okay, thank you.
Thank you, Your Honors.
Mr. Clevey, good morning.
Good morning, Your Honors. May it please the court. Your Honors, it's the appellee's position in this matter that Judge Krupp correctly ruled that the bylaw was enforceable as it relates to this litigation. I think the linchpin of the appellant's arguments as it relates both to their public policy argument and the conflict with the condominium statute rests on that conflict with the condominium statute. In other words, this bylaw, this 80% voting bylaw, directly conflicts with Chapter 183A, Section 10B4. It's our position it does not conflict with that statute. It's actually in accord with that statute.
What if, I mean, 80% is very high, but what if it was 99% and one unit owner could essentially veto the ability of the board to institute litigation?
I think a 99% voting percentage would be extremely high. I don't think the 80% is extremely high.
Would it violate the statute? Would it be in conflict with the
I
statute?
don't think it would violate the statute, though, because
Would it be void against public policy?
that may be an argument if it's 99%. I think if it's that high, and and there's facts that differentiate this case from that, but then you'd potentially have that public policy argument. But with respect to the 80% provision, I think we should keep in mind that this is really litigation for the purposes of improving the common areas of this condominium. They're suing the developers, then using that money to make improvements to the common areas. And when you look at the Condominium Act, there's 2 statutes within it that provide for a 75% majority in order to make such improvements, one after a casualty loss, a fire or flood, and the other if the improvements to the common areas are going to be more than 10% of the value of the condominium.
Do they have a 60-day rule too? So it's not only 80%, it's 80% in writing within 60 days, which have, that's kind of, getting a condo to move that quickly is remarkable, and it
The
suggests.
legislature statutes do not have a 60-day rule, Your Honor.
So
but
we have 80%, 60 days in writing. Doesn't that suggest that it's just a way of preventing, and it's also only limited to certain kinds of lawsuits, which are the ones you bring against the developer. So isn't there some sense of overreaching when you put all those things together?
It does
It's a
not-
question, not a
Yeah, it
rhetorical.
does not just preclude lawsuits against the developer. The only lawsuits that do not fall under it are lawsuits against unit owners for assessed costs. Otherwise, it pertains to every other lawsuit the condominium could file. If they got a new roof and it ended up leaking, the same question would go to the unit owners. Do we want to spend the money on litigation, or do we want to spend the money on repairs?
Isn't the roof case just like our case, meaning the building wasn't built well?
Oh, yeah, yes, I think it would. It wouldn't involve a developer necessarily, if it was new construction or something that was done recently. But this bylaw would apply to every other party that they wanted to sue for breach of contract, for trespass upon the property, for some type of nuisance claim. So it's not strictly related to developers. We happen to be arguing the facts where it was applied to the developer and it came out unfavorably with respect to that.
What's the purpose of this bylaw? Is it unit owner autonomy, or is it to protect the developer?
Unit owner autonomy, Your Honor. I mean, this is a $600,000 bill that was presented to these unit owners. And again, when you look at section 17 and 18 of the statute, there's a legislative purpose in there to say when costs are going to be so prohibitive for a unit owner who may be on a fixed income, or whatever, that more than 50% is okay, and it's 75%. And 80% is not very far from 80%. It's 3 out of 4, and 80% is 4 out of 5. It was taken from an MCLE provision. I don't know how that number was ascertained.
And you just remind me of another provision, which means that they have to have an immediate assessment, right? So they have to estimate the legal fees, which is difficult, and then immediately assess that amount to the condo. Is that, am I reading that provision correctly? Is that what they have to do?
I think they have to do an assessment immediately, but it doesn't have to be, this bylaw doesn't say you have to say for that full amount. So if there's a proposed $600,000 legal fee.
I thought the provision did say for, am I misreading that? Because I thought it did say for the whole amount, a full.
But I think, so you could, if you have a $600,000 legal fee, you don't pay that up front. It's an estimate as to cost.
Specifying as part of the written consent a specific monetary limited to be paid as legal fees and costs and expenses to be incurred in connection therewith, which amount shall be separately assessed as a special assessment effective forthwith. So that doesn't require you to do the whole amount?
No, I think you make a special assessment as to how much will be paid for the purposes of the lawsuit, probably dependent upon what's put in for a retainer at that time. We've paid a $20,000 retainer. Now we're going to the unit owners and saying there's going to be an assessment for what we've paid out. I don't think that means we have a $600,000 estimate. Let's go to the different unit owners and start collecting $600,000 at this time.
Is there a public policy violation or issue when the plaintiffs have to show the defendant the complaint to get the defendant's assent to sue?
That was the situation in this case, Your Honor,
Right,
correct.
that's why I'm
but
asking it.
I don't find any public policy violation with respect to doing that. I think the argument is you're violating, the work product doctrine and maybe the attorney-client privilege, but the facts in a complaint and legal theories of a complaint that's going to be filed, I mean, those are just the facts you're going to be relying upon, in the theories. There's nothing really with respect to important mental impressions, anything significant that's being given over to the other side. And we talked about this with Judge Krupp at the trial court level. It's very often that a draft complaint is sent to the other side, an insurance company saying, here's our case, this is what we need to understand. And it serves a very legitimate purpose in this, some transparency for the unit owners. They get a vote on whether or not to approve litigation. What better method than to have the complaint in front of them so they can make some type of determination as to who the parties are, what the actual allegations are, what's the legal basis for it. They could go out and seek their own attorney and say, what do you think about this? So it serves a very legitimate purposes for all of the people, unit owners within the condominium, to have that complaint and look at it to make this decision before they make a very large expenditure for the purposes of the lawsuit.
So, but if the lawsuit's not pursued, then the condo owners have to pay the cost of repair.
That would be correct, Your Honor.
So that would be assessed without any vote as to whether or not they should do that. Somebody, either you basically get reimbursed for it through a lawsuit by having the developer who's the source of the defects pay for it, or you pay people yourself to repair the defect and then you swallow that cost.
That very well could be the situation, Your Honor, but going back to 183B4, there's other sections that provide powers to the trustees, the power to manage the property, the power to lease the common areas. And so manage the property includes making those repairs. If this court were to adopt the argument that by saying you have that power, that's unfettered power that can in any way be controlled by the unit owners, who the trustees are acting as the beneficiaries, are the unit owners of the trust, that they can they can enter into any contracts they want. So the other side of it is now the unit owners don't have any say whatsoever. They go to their mailbox and there's an assessment for costs, and they say, I don't even know why I'm getting this.
Yeah, but then just to keep with Justice Gantz's point, if they don't do the lawsuit, then you're going to be able to impose the assessment, and if you don't pay, you're going to be able to sue that unit owner without going through this 80% rule, right? So there's no, you're going to be able to sue the individual unit owner without the 80% rule if they don't pay the condo fee, right?
That's the way the bylaw works, Your Honor. I think those suits.
Seems like it's a one-way street.
Well, it definitely provides an exception for those suits against unit owners for assessed costs, but those are very common suits. So it serves a practical matter of not having to go to the unit owners every time someone's late with one of their assessment fees, paying it to the condominium board. And I think what maybe it also avoids too is letting a condominium unit owner decide, am I going to collect the assessment from my neighbor? Because I think that might put the condominium in itself and the board in kind of a sticky situation where, people are politicking. I don't want to be assessed this, and it becomes a likability contest. Well, we all like this person, let's not assess them. So it just gives the Board of Trustees that power. I think that's a perfectly reasonable way to approach it, and I think that's what the bylaw does.
So why is it not overreaching for a developer to include in the bylaws a provision that says basically unless 80% of you agree, then you will not be able to sue me for any defects in the construction of the common areas of the condo that you are involved in purchasing?
Why is that not against public policy, Your Honor?
Why is it not overreaching? It's a rather
Well,
extraordinary thing to say 20% can veto any effort to attempt to obtain a remedy against me for the defects that may be latent as a result of my negligent construction.
Well, correct. I think in this case, it turns out that's what the case is about, going after a developer. So, we have the Betancourt case with the same provision in a Rule 128 decision. They were suing the trustees and unit owners, and this same provision prevented a lawsuit against. So it serves a legitimate purpose other than as to the developer. But with respect to the developer and with respect to the public policy reason is because there are unit owners in this condominium who voted against this, who did not want this to occur. We refer to Anahid Madaros. She's one of the defendants. She's in no way involved with the developers. As it happens, she owns 14% of the condominium unit, so she'd have some say into what would happen. She voted against it, as did 11% of the other unit owners who are in no way affiliated with the developers. So they didn't get the 20% regardless of the developers' votes in this case.
But in the world that you describe, it would not matter, I gather, if the developer said, I'm going to hold 20% and then rent it out, so that I retain the ability to veto that. That would be permissible in your world, correct?
I think that's a different set of circumstances, and I think you kind of, now you're getting into issues of discounting specific votes within the condominium context. And, it's kind of a sticky issue, because I understand from the court's perspective, well, this developer's never going to vote for a lawsuit against him. Of course not. But the other part of it is, you do want his money. You want his money for the assessments. You want him to pay for this. Well, then maybe he does get a vote. So, I'm not sure where that comes down.
But the provision which your client wrote doesn't exclude them. So right now, they get a vote.
They do get a vote.
If the developer retains a unit and rents it out, they get a vote.
And so, right, and it's really, it wasn't argued in the brief with respect to discounting these votes. We did have that issue come up initially before Judge Rosalind Miller down in the Superior Court, Your Honor. And at the end of the day, Judge Miller's decision was, people get to vote as they want. We're not going to look at bias or whatever. These people are all shareholders with respect to this condominium. And again, if they're going to pay the freight for the litigation or the repairs, they get to make a vote in their own interests.
She started out with a percentage of disinterested owners, right? Unit owners. That was the first ruling, was a
Yes.
percentage of disinterested, and then it moved after that, right?
We did a motion for reconsideration, and it was in her response to the motion for reconsideration where she said, I'm not going to look at who's voting for what reason. And I think there's a good reason why. Are we going to start doing discovery into the motive of everyone's vote?
It is an issue in this case as to the 14% owners. I forget the name, whether they were disinterested or not, correct? That's an issue that we don't have to reach. That was an issue in the case.
With respect to what, Mrs. Mataros?
Yes.
I mean, it's alleged that she's interested, but there's no affiliation between her and the developers. So did she serve as a Board of Trustee member with them? Yes. I mean, and I don't know this. Could she be friends with them?
I'm
Yes.
distracting you because that's not an issue before.
Okay,
Go ahead.
but if I'm a buyer and I carefully go to the registry and read everything, how am I supposed to know that perhaps the developer's going to retain 20% of the units itself and rent it out?
You could look at the deeds and who owns the specific units, Your Honor.
What if I'm one of the early buyers?
Excuse me?
If I'm one of the early buyers, am I going to know who's purchased all the other units?
No, you would not, Your Honor.
So how am I going to know that I've not effectively given up any remedy against the developer if the developer were to choose to retain some amount of units?
I don't think a person in that case would know. Again, this isn't a case where they're not filing the lawsuit because the developer's got the 20% voting block. Because there's another 20% voting block that wouldn't approve for this anyways. I mean, there could be a theory where, you take the interested developers out of the equation. I mean, that's a potential resolution.
If you did that, then you'd have to go to the issue that Justice Gaziano raises, then you'd have to determine what is the financial interest or the financial stake of each unit owner, which appears to be what the judge said. We're not going to go there, and that's not before us. That's not what the provision says. The provision doesn't say 80% of the disinterested unit owners. It says 80% of the unit owners.
Right. So enforcing it on its face, correct, the developers get to vote in their interests. And, and the other side of it is, we're not looking at anyone who votes in favor of it, we don't want to look at their interests. It's almost, if they're voting in favor for it, we take that at face value. But, I don't know if through discovery, if you ask people, why did you vote in favor for it? They say, well, my neighbors voted in favor for it, so I did too. I mean, when people go into the voting booth on something like this, you get to vote for their own interests. Your own interest can be, I want them to pay for this, or as Ms. Anahid, I don't want to get stuck in expensive litigation that I may deem at the end of the day isn't going to get me anywhere. I don't know if there's liability. I don't know if there's collectability. So when you're telling me I've got to spend $600,000 on the uncertainties of litigation, I don't want to be any part of that. And I think when we go back to this public policy argument, well, when one of the arguments raised is these individuals don't really read the condominium documents, so they shouldn't be bound by this provision. Well, the other side of that is there's a woman who did read the documents and wants to be bound by the provision. And I think when you're weighing public policy concerns, you certainly weigh it in her favor. I mean, this is a purchase of a condominium. It's an expensive piece of real estate. There's an expectation that you're going to read the condominium documents because it's going to affect how you live for however long you're going to be there. And something even as innocuous as a no pet restriction would make the difference between someone living there and not living there. So I would expect anyone that's going to move in would read the documents, and I'd further expect that anyone that's going to purchase the condominium would do so with the assistance of an attorney who would certainly, I would expect, explain the significant portions of it and how it would affect your living there.
Are there any cases besides Betancourt, the 128, that affirm these types of provisions in any other states? I'm sure this is somewhat of a...
I think we referenced a Michigan case, Your Honor,
So
in our brief, or
so the two
the
cases
appellants
on
did.
two cases on point in your favor are Betancourt. I mean,
The
other
Michigan
cases
case-
you can reason by analogy, but the two cases interpreting these provisions are Betancourt and the Michigan case.
Yeah, and I think the other case might have involved the Uniform Condominium Act or something, so it might be on a little different basis.
Okay, thank you.
Thank you, Your Honor.
Court all rise.